What matters can be addressed in a postnuptial agreement? Attorney Brian McNamara explains that. There are minimal limits on what can be included in a postnuptial agreement. It cannot include a provision that limits support of children. Other agreements about children are unenforceable because nobody can predict what will be in a child's best interest in the future. An agreement might state a parent will get primary custody of the children, and that parent might have developed a drug problem or a mental illness, and a court will not enforce that part. Children should not be mentioned in a pre- or post-nup, but they can be. It just is not enforceable because the law will do what the court perceives to be in the child's best interest at the time the decision is made. Technically, Texas law says you cannot limit the right to support of a child. What that means is you could, for example, say a minimum level of child support must be paid at least this much so that the judge could exceed it, but you cannot limit it to a specific amount. Texas Family Code Section 4.003 refers to a premarital agreement. It says the right of a child to support may not be adversely affected by a premarital agreement. So you could set a minimum child support owed, but not set a maximum. The statutes regarding prenuptial agreements specify broad latitude in negotiating the agreement. The post-nup statute refers more narrowly to partitioning the community estate into two separate estates, so it's not as clear how much may be included in a Texas postnuptial agreement. Contact attorney Brian McNamara in Houston, Texas for an initial consultation at 713-955-1844 or visit his website at www.houstonprenups.com.